These days, we're able to do almost everything online. Nearly all businesses have a website and many have their own apps.
When you sign up, you usually have to accept some kind of usage agreement, but do you ever really read the fine print?
You should. News 6 Insider Guide Crystal Moyer is here now with a consumer report.
I'm sorry, ladies. You know, when you're scrolling down, we do not have time to read that fine print. Most of us just click OK, and we just go ahead and click on we agree. And we start downloading that program. But if you actually read those very tiny words, you might be surprised at what you're agreeing to. Consumer Reports reveals the most common hidden clauses and what we all may be signing away.
Can you guess what app makes you agree to not develop, design, or manufacture nuclear weapons when you accept their terms?
Apple iTunes.
That's right, Apple iTunes. Consumer Reports' Justin Brookman is an expert in consumer privacy and technology law and sees a lot of wacky clauses hidden in user agreements.
You promise not to get drunk on Tumblr's usernames. What does that even mean?
And this one, in the case of a viral infection that causes human corpses to reanimate and likely to result in the fall of civilization. Translation?
I guess it means that in the event of a zombie apocalypse, Amazon's not going to sue you. I think in a lot of these cases, the company's lawyers are just having fun.
Fun aside, Brookman says there's a lot buried in these agreements that could limit your rights if something goes wrong, including ones that seek to prevent users from posting negative reviews. Take Intel, which says violators will be prosecuted to the maximum extent possible. Intel told Consumer Reports it's to protect the company from inaccurate reviews, but hasn't enforced it recently. Many of these clauses may now be illegal due to the legislation passed a few years ago, but some companies still include them.
I think it's a scare tactic. I think they know that consumers don't necessarily know the law. But if you lie about them, if you defame them, then that's not protected and the companies have a right to sue you for it.
Some go further, saying you can't sue a business over a dispute, making you resolve your issue outside the courts with an arbitration clause. AT&T uses language typically in many agreements. You are waiving the right to a trial by jury or to participate in a class action. AT&T declined to address why the company sought to eliminate the possibility of class action lawsuits, but argued arbitration is faster and less expensive for consumers. But Consumer Reports says that's not fair.
If your product breaks, if something goes wrong, if it hurts you, you should have a right to go to court and sue them for the damages that it caused.
Unfortunately, Consumer Reports says there's really no getting around accepting terms if you want a product. So best to opt for products that don't require mandatory arbitration when resolving disputes. I'm going to post some more details on clickorlando.com/insider. Ladies, a zombie apocalypse. Come on now.
It could happen.
I feel like I agree so many times a day, and I've never read any of them, I don't think.
I know.
It's a test. They're putting zombie apocalypse in there. They're trying to see how many of us actually read and how many people would send in an email asking questions.
Right.
Not
Don't
very
get
many.
drunk on Tumblr, ladies.
Don't do that.
Need a new hobby then.
All right. That was fun. Thanks, Crystal.